camera. All right. I'm going to wait till we get a little more just to talk more about the test because everybody's got questions about the test. But today we're going to talk about leases. All different kinds of leases, different things that make up leases. Probably most of you in this room have been a party to a lease at one time or another, unless you're still living at home or you own something right out of school, both of which are unusual. Most people sign a lease either for their home or for their business. There's not a whole lot to talk about in residential leases, but I wanted to at least show you some of how it works, and that's one of the forms. I gave you, during the week, a bunch of forms, and we're going to go through some of them. I'm going to discuss the importance, but it's things that are helpful to understand what goes into a lease and why. As you may be aware, you have to have a license in the state of Florida to practice law. That's probably pretty easy. However, there are certain things that the bar and the Supreme Court have said that in order to make business happen, they allow certain people to do certain things. And one of the things that's allowed to be done is if you are a real estate agent or broker, you're allowed to fill in the blanks on pre-approved forms. That's the first class we talked about. I showed you the contract. I think it was a commercial contract that is a product of the Florida Association of Realtors and the Florida Bar working together. And technically speaking, a real estate broker or agent is really only allowed to fill in the blanks on that form. What happens is, and what causes me the most aggravation when I see it, is when they go into that area. Remember, I think I said half jokingly but half seriously, the special clauses at the end, which are all those blank lines. And they start writing things in. And when you write things in, if they're not complete, then it causes problems because by not being complete, there's a lot of what-ifs that we have to deal with. And that's what causes deals to go sideways. It's what causes people to fight over deals, makes lawyers crazy. But what happens is people write things in and sign it because they want to make the deal. I think they're doing a good thing. Less of a problem with residential until you start getting into contingencies that get thrown in. My favorite is this contract is contingent on the sale of my house at 123 Main Street. Well, that's all it'll say, and that's a whole bunch of problems. There is a form that the Florida Association of Realtors has produced that expands on that and does that clause right. But that's the things. The reason for this explanation that has nothing to do with leases is the form that I put on the screen and is in your, I emailed it earlier a couple of days ago. And this is a residential form of lease. Be careful if you're out in the marketplace, either as an agent or as a landlord or tenant. There is another monster out there called a contract to enter into a lease. And it looks like a lease, it smells like a lease, it is not a lease. In fact, I didn't bring the form, but it says so right at the top. This is not a lease. And it's not quite a letter of intent, but it seems to have all the terms and conditions that would go into a lease, and I don't know why people use it instead of filling one of these out, because it's got almost the same information. But this document has all the essential terms. This happens to be for, as you'll see, single-family home. So it's got different provisions. There is another one for apartments and condominiums, and they say specifically up there on the top which it's for, and there's reasons for it. In fact, I think the other one says do not use for a single-family home. The other thing you'll see that's important is the second line under the heading. It says for a term not to exceed 1 year. First of all, a lease for more than 1 year becomes a conveyance of land. And it requires 2 witnesses for the landlord, just like a deed. I mentioned briefly, and I want to make sure to stress this, that a leasehold, historically, is a conveyance of land for a term of years. It's also a contract. It's governed today by contract more than property principles, but not 100%. That would require a lot more legal intervention to do a proper long-term lease. So when they created this form and the companion condo form, they restricted it so it could only be done for short-term, for one-year leases. And even if there's a business arrangement between landlord and tenant, that the tenant has the right for a second year at the end of the term, you're supposed to sign a new lease. That unless you have, you know, some people, it's rare, but some people will come and have a lawyer help them, even with a house lease or a condo lease, and we can write something up that will, like an addendum to this, where they can make it more. I've seen it just recently, strike out that line up there and put in the proper witnesses and put in the proper information for the option to renew. Not necessarily common in a residential lease, but from a tenant standpoint, it's a good thing to have because you know you're not going to get thrown out. Options of any kind are only run in favor of the person who holds the option. Whether it's an option to renew or an option to purchase or anything like that, it benefits, for purposes of today's discussion, the tenant, not the landlord, because that's where the rights are. Talk about the parties, the property, it's all easy. The term we talked about, rent, and this is fairly simple. And it's all laid out here where someone can just fill in the blanks and put all the stuff in that you need so that it's supposed to be foolproof. It talks about, here's the section, who's, you know, first, last security, other deposits, pet deposits, homeowners association deposits, those kinds of things, late fees, whether or not you're allowed to have pets. And by the way, well, since we're on the topic, since we just happened to pop up, a properly documented emotional support animal, or more importantly, and more clearly, a service animal, is not a pet. And so if someone, there is a distinction between a true service animal and an emotional support animal. And I will tell you off the bat, I'm very pro-animal, so I love dogs, cats, and anything else I want to take my hand off. But even if you have an apartment building or a condo that is a no-pet facility, where the lease says no pets, you can have a service animal. That's the law. It's an accommodation, similar to an accommodation under the Americans with Disability Act. It may actually be under the same laws that says you have to allow that. If you have an apartment that has a one-pet policy, technically you can have a pet and a service animal, because a service animal is not a pet. There's been a whole body of law recently. This is a relatively new thing, and it's more than seeing the little old lady with the foofy poodle on the airplane where she spent extra money for the vest, and she's got a letter from the doctor of great postage who, you know, you send in $20 and you get a letter saying it's a support animal or a service animal. That's not what we're talking about. I mean, that's great, and I know, unfortunately, I know several people who do it because they want to be able to travel and not take the dog and put it underneath in the cage like the old days. They want to be able to put it in a little carrier and take it to the airport. That's what happens. But as long as it's not a problem, it's not a problem. But it's abused. That's the point. It's abused. My last trip, we had kind of a hard landing coming into Fort Lauderdale, and didn't know there was anything nearby on board. Well, as soon as that plane hit, and it hit loud, there was meowing starting about 2 rows in front of me. The cat was obviously scared and started protesting.
If I see an animal on a flight, I would get off.
Why?
Because to fly with an animal, they're loud.
No, truthfully, most of the animals that fly in that situation, that are in the bag, that are underneath, they've either been well trained or slightly sedated. And I was on one flight, and this guy had a golden retriever. What?
They sedate them?
Yeah, a golden retriever, big dog, yeah. Which I didn't have a problem with because I was sitting on the aisle, he was sitting in the window. When I first sat down, the dog was in the middle. Now, I had no problem petting the dog, I had no problem with that. And then a passenger came into the middle seat. So he had to put the dog between his legs and under the seat. Except under the seat, he had another bag with a cat in it. It was a little crowded, and the woman in the middle was completely offended by the fact that these animals were there. The animals were great; there were no problem at all. Most of the traveling animals are not a problem at all. You know. Now, I will tell you, if you watch the news, at least one airline absolutely came out with a particular type of ban. There was a passenger trying, and I'm not kidding, I can't make this up, they were trying to get board with their emotional support peacock. And the airline said no.
I would lose my
Peacock.
mind if there was a
Peacock, yes.
in my flight.
Large bird.
Those things are mean too.
They can be mean. They can be, oh, they're fine. I mean, they can be very nice
I have,
too.
like, ponies.
But there are miniature horses that,
Ponies, horses.
you know. But remember, some of them are support and some of them are service. I mean, some of the dogs and cats, particularly some of the dogs, they can sense with their sense of smell. Someone with diabetes, all of a sudden, if their blood sugar drops, they give off some kind of a scent that the animal notices, and the animal can either call somebody, you know, bark for somebody, or help the person get to the medicine. So it's amazing what can happen. Same thing with seizures, all kinds of things.
Yeah.
So
I
you never
love
know.
the animals. I just can't fly with them.
Well, listen,
But how do they? You say there's support and there's
there's service.
But
Support, for example, let's
business
say,
aren't. They're not allowed to ask about it though.
no,
Yeah.
you're not allowed to ask. If you have a piece of paper that says, or I don't know if the vest is sufficient, but if you have a document that says this is a legitimate animal, they gotta allow it.
Because they don't even have to show the document.
I think you're probably
Because I
right.
worked in hotels.
Really? Yeah,
I worked
well,
in
at
hotels
the
and
bank
we
when we
can't
learned
do
about
that.
that and someone comes in with a service animal, you're not supposed to
You're not-
ask.
you can't
Oh, is that a
inquire
service
about it.
animal? They're not supposed to ask for any of that kind of stuff.
That's why people
Bro,
have all
Are
these
there
different-
restrictions of animals? Because I've seen clipboards on planes,
So,
and they are,
no, they're not, if it's, no, it doesn't matter. And by the way, don't, I've known some very nice, pleasant pit bulls. They get a bad reputation if they're raised wrong. So you know, there really isn't a dog that is bred to be bad. They're raised to be bad. That's so.
I've never seen people that would pet them.
You haven't met the right one.
Too bad.
There's some people I wouldn't pet. Okay. All right. So let me just see if there's anything special in here. I don't want to spend a whole lot of time on the residential lease. I just wanted to show it to you. Oh, and there are a few things in here that are interesting that you should see. Take a look at paragraph 14. There are special rules both in landlord-tenant and in mortgage foreclosures that we'll talk about in a few weeks, dealing with military service personnel. And basically, what it says here is that if someone is in the military and they get called up, they can terminate their lease without a penalty. As it should be. I mean, you know, let's think about it. They're serving the country. There's places here where it talks about the statute and rights of entry and use. There's something else I wanted to show particularly. Now, C-22, it shows that this can only be extended by a new written agreement, because this lease, and it says at the end of the paragraph, a new lease is required for each year. I just want to see. You'll also notice on this document, to compare to what I'm going to show you when we get to the commercial leases, there's no witness lines, because it's not required for a lease of less than a year. In fact, there is legislation proposed that will be discussed in the Landlord-Tenant Committee of the Florida Bar, and I think it's going to go on to the legislative committees and so on, to eliminate the requirement of the 2 witnesses on a commercial lease, because Florida is one of the few states that requires it. You know, the requirements of execution vary from state to state by state law. As I think I told you, I hope I told you, a deed, for example, does require 2 witnesses for it to be valid. So does a lease for more than a year, because it's by the landlord's signature. Everybody does both, but the landlord's signature particularly, because it is a conveyance of land under Florida statutes. So,
What does a conveyance of land mean?
transfer, like a deed. A deed is conveying, transferring. I'm taking my land, I'm giving it to you.
So,
Now, in a deed, it's permanent. In a lease, it's for a term of years.
oh, okay.
And they always have that lead paint thing in there, right?
Yes, I'm trying to see.
And then they can, that changes what they can do and can't do with the property, if you do get a 2-year, and you do convey for that 2 years, or is it just something on paper?
Well, the contract will provide who has to take care of what. I mean, here, you just take a look at the various restrictions. Restricts overnight guests, restricts pets, other stuff is normal stuff. Then it allocates maintenance as to who takes care of what. If it were really a true conveyance for a term of years, and I said, I'm giving you my house for 2 years, period, end of story.
Yeah.
You have to take care of everything. Anything that breaks, your problem. You would probably not like that, okay? It's different if we're talking about a commercial building for 10 years. But typically a transfer for a short term, or again, residential is much less formal, or when you think about it, really the tenant doesn't usually take care of all that much.
Is there a difference in the two?
Between what?
Well,
No, I don't know. It's a
there's-
very good question. I don't
there's
see.
2 leases that are like back to back, so.
Yeah, and I don't know why there's a difference. I was looking at it, but although it's funny, the second one has witnesses.
And also uses Roman numerals.
Maybe it's a Roman lease. I hate Roman numerals. It makes you think too much. It's helpful when you're formatting a document.
So how does the witness closing, like, or witness signature happen? You have to have the
Person has to be sitting there seeing you.
3 people?
No, 2.
But if you need 2 witnesses,
2 witnesses. 2, so you have the,
you have to have 3 people there.
well, maybe 4.
4.
Well, maybe even 5 with the notary, no?
Yeah, see, like, how does that work?
Well,
So-
Okay, easy. So, it depends on what you're signing. Let's say you're signing a deed. Deed is everybody that owns, so whether it's, and they're called grantor, okay? Could be A and B, could be husband and wife, could be 2 partners. The grantors have to sign the deed, 2 witnesses, and a notary. One of the witnesses may also be the notary. That is specifically allowed in Florida.
Oh, is it? Because when we've done notarized documents in the bank, there's the person signing, and then
2 witnesses.
2 witnesses,
And a notary.
the notary is,
Well,
yeah.
but that's pretty common if you have enough people. But if you don't have enough people, it's specifically, all the title underwriters say, and it's no problem if the notary is one of the witnesses. And that's actually used, I've seen that used to correct screw-ups, like if it's with mail-away closings, where the documents aren't being signed in front of you, that it'll come back with only 1 witness and a notary. And if the notary is different than one of the witnesses, you can send it back and get an affidavit saying that the notary says, I was physically present and saw them sign. So then they can sign as a witness and that fixes it. You don't, interestingly enough, this is something most people wouldn't realize, if you look at the notary block, the notary block says that the person acknowledged before the notary public, in the case of a regular document, if it's an affidavit, he swore before the notary, that he's the person that signed the document. That doesn't mean necessarily that the notary saw them sign their name, because the notary's not being a witness in that case. The person can separately acknowledge to the notary that that was their signature. So it's 2 different acts technically. As practical purposes, in most cases, it all happens at once.
I've never seen a notary say, take a signature from somebody. Unless it's a special case, it's a personal bank, stuff like
It wouldn't be where the notary did it separately. It would be a situation where a person had a signed document in front of 2 witnesses, and then went to the notary personally and said to the notary, I signed this. That's why I said, I'm acknowledging to you, which is how the document actually reads, it's called an acknowledgement. I'm acknowledging to you that I am the person that executed this document. And here's my identification to prove that I'm that person, and that's okay to notarize. Now, we have a new torture that's just been passed as of the 1st of the year that I am sure is going to cause trouble. And that new torture is online, remote online notarization. I'm not going to talk too much about it, except it's just the words you hear. With the right formalities and the right certifications, you can have a person and camera in another place acknowledging before the notary that he's the person that signed it. And even though that notary is in Florida and that person is in Texas, it can be validated. I'm just waiting. I mean, it's not like we don't have enough fraud that goes on when it comes to this stuff, that this is just, to me, is just another door open. The other thing, not that any of you are really preparing legal documents, but we've had to change the notarization block, the acknowledgement block, to have presently there has been for several years a choice box that the person is personally known to me or produced blank as identification. It's usually a driver's license right in there. Now there's a second choice box supposed to be in there. This was acknowledged before me by means of physical presence or remote online notarization. And you have to check that box. Personally, what I'm doing is I'm just putting the means of physical presence on my own documents, and I've gotten that clear to the underwriter because I'm not participating in the other. As long as I'm reciting what the law requires, it's valid. So that will be the next torture.
You said there's a lot of fraud going on?
There's always fraud going on.
Well, I was going to ask you because, well, at least with fraud in the bank, so I used to work for Wells Fargo.
I'm sorry.
Yeah, I know. Wells Fargo, whatever you want to call it. Anyway, of all of the fraud or fraud losses that Wells Fargo takes, more than half of it is in Florida, and
We're number one.
3/4 of Florida is in South Florida. So is that like in your line of business as well?
Not yet.
Or is it just all across the country? It's kind of even, or is it mostly?
Oh, no, we're
mostly
special.
in Florida.
We are special.
All right, that's what I thought.
Yeah, Miami.
We are
I
special.
always hear it, but like I don't know to like what capacity. You know what I mean? Like, you just hear like people make
No, I'm just
jokes,
saying.
but then like
Because what happens is you have people that
Maybe
come
not
to
so well.
Florida from the Northeast. I won't mention any particular states where
Not New York, and not
where they have trained specifically in how to commit fraud, or they come from places in South America where the rules are different and it's okay to do certain things, or they come from Eastern Europe where there are no rules at all, and they come here and they find people who are just easy to work with.
Yep.
And they bend the rules and they do things and whatever happens. No, I mean I'm not saying that everybody that comes from any of those places is bad. I'm just saying that when you see who's committing the frauds and doing things, that just happens to be what the result is. So it happens. So I mean there could be things like a forged signature. It could be things like intercepting a wire transfer instructions and switching something so that the money goes this way instead of where it's supposed to go.
where isn't that illegal?
What?
Where isn't that illegal?
Where isn't that illegal?
Yeah.
Oh, it's illegal everywhere. It's just I don't think you're going to find many people from Iowa that are going to be doing that. I don't know why, but
Where?
Iowa.
Oh yeah.
They're nice, People from the Midwest don't do stuff like that. I'm going to tell you. All right, back on topic.
They have to have their other ways.
Everybody's got their ways. They smile at you. They make you think they're trustworthy.
They just live in a bubble.
All right,
They seduce you into religion.
I'm gonna bounce back and forth. I just want to show you the outline. I'm going to talk about different types of leases and why, and different issues. And if you're all well behaved, at the end of everything, I'll do the cannabis leases, because I know that always keeps everybody's attention. And that's just by the topic. It's really, it's something that I got involved in because my firm does a lot of it, and I was working with people, with clients out in the Western United States before we had real estate lawyers out there, and there's just different issues. A lot of it's basic stuff and different issues related to it. Okay, so I'm going to talk about commercial. Everything I'm going to talk about in the leasing module, except for what we just did, is commercial. Because there's really no, while you could theoretically have some of these nuances in residential, it doesn't happen. Residential is very vanilla and straightforward. The only thing you're going to see in residential is who's going to take care of what. Who changes the air conditioning filter, who cleans the pool, who mows the lawn. That doesn't require a whole lot of brain exercise. So the reason that I start off with the different types of leases and by premises is because the way those leases interact the landlord and the tenant and the different responsibilities and who does what varies tremendously by what kind of a lease it is. An office lease, for the most part, is typically you have a business that needs a box to sit in. Kind of not so different from this classroom, except it would be desks and chairs instead of the tables like this. They don't really want to worry about anything. They're just renting an office to do business. They don't worry too much about changing light bulbs. They don't want to worry about the plumbing in the bathrooms. They don't want to do anything like that. They just want to come in, do their work, and if there's a problem, they're going to call the landlord. Other than that, they just don't want to be bothered with it. So the landlord side of it is they want to make sure, because it's how their investments work, that they get rent for their whole building. Again, this building is a really good example because it's not that different from an office building. So here we have the office, this classroom. To get here, you came in a door, you came through a lobby, you came upstairs or an elevator, you walk down a hallway, there's public, restrooms, common restrooms. All of those things are not part of the leased premises. Those are what's called common area. It's common, all the tenants in the building are going to use it. So, one of the things that you see, particularly in an office space more than some of the others, is a load factor. A load factor is an add-on percentage, and in market it's usually 12 to 15% in most offices. And what that does is, let's say you're renting a 1,000 square foot office, which is 1,000 square feet measured. And I'm not going to get into the details. There are ways to measure, into the middle of the wall, not counting the columns. I mean, this has got some irregularities in the back where the walls dip in because there's columns and things, but there's standard ways to measure. Let's assume we're talking about 1,000 square feet of usable space. That's a term of art, usable space. Well, when the landlord wants to recover rent for his entire property, he now adds the load factor and charges for rentable space. So my 1,000 square foot of usable, you add 15% onto that. Somebody? Anybody? 150 feet? So it's 1,150 of rentable. My math good, please?
Yep.
Yes. Okay. So now you're paying rent on 1,150. That's a load factor. And it's accepted and it's what you're paying on.
And that's to cover like the common area.
The common area.
Okay.
That way the landlord gets to earn rent on his entire property. Different types of properties have less common area, so less of a load factor. For example, if you have ground floor offices, like in an office park, where you have parking lots and you go right into the door of the building, then there is no hallway, there is no elevator, there is no common facility. So that you should have a lower load factor for stuff like that. Retail is a little different. Typically in retail, if you're inside a major shopping center, yes, you're going to have a load factor. But inside the retail store, there's going to be bathrooms and basically a box. And the bathrooms are the tenant's responsibility to the wall, because it's now their private bathroom, so that gets shifted over. Taking care of the light fixtures is the tenant responsibility. Depending on the configuration of the property, the tenant may be obligated to take care of the air conditioning unit that serves that particular retail space. So to that extent, there's a huge difference between office and retail in the responsibilities. Now, some office leases, if they're longer, if they're freestanding, different things, some of the responsibilities get shifted, but typically that's different. Mixed use is just that. You see a lot of mixed use facilities now where you have an apartment building and then you have retail stores along the bottom. That's very, very common today because that's what the cities are all trying as part of urban planning to do, to try to have the work live together. So you'll see that all over the place. Unfortunately, if you look around, you go drive through downtown Fort Lauderdale area, and you see all these new, 6, 7-story buildings with the retail. There's a lot of empty space. Mm-hmm. You might find a fitness center, which is either a fitness center open to the public, or perhaps it's the fitness center that's been put in as an amenity of the building, and they're occupying street front, glass. You go by, you see the people on the machines and such that they can look out while they're working out. That could be a use of that space. Sometimes you'll see small businesses, dry clean drop stores, rarely food service, but all kinds of little things in those. That's the idea there. That's mixed use. Sometimes there's offices in there as well. So when you have mixed use, you have to do a couple of different things. You have to allocate who's paying for what to take care. We're going to get into expenses in a minute, but you have to, different components of the building are going to use services for the building differently. So a mixed use lease has to get a little more complicated when you start talking about common area expenses, maintenance costs, depending upon whether you're talking about a residential unit, a retail unit, or an office unit in the same complex. You may have to apply different sets of costs to what the contribution of that tenant is. Ground lease is real easy. Ground lease is literally a lease of a piece of dirt to a tenant who's going to put their own improvements on the dirt. They're usually long-term, like 50 years, and the reason for that is that if the tenant is going to build a building on it, the tenant needs to be able to amortize its cost over the life of the lease, and at least, and even if they leave sooner, they're going to know they've got to have a certain amount of time to make their investment worthwhile, because when the lease is over, the tenant can't take the building with them. The building stays, and that's part of the bargain that the landlord is making. The landlord typically will do nothing in terms of improvements, expenses, anything. It's, here's my land, you pay me X dollars a month for, for years with rent escalations, and that's the end of it. Tenant pays the taxes, tenant pays the insurance, tenant builds the building, tenant maintains the building, everything. Okay, that's a ground lease. So I'll talk about the cannabis leases later. Okay. Let me now talk about some of the provisions. What you see here, I'm not going to leave this up. I want you to take a quick look at it, because what I'm going to do is I'm going to try and show you what some of these things look like, some of the concepts and how they work and why they work. But I can talk just for a little bit about it, and then I'll do that. So there's some pretty basic provisions to any. Yeah, sorry, yes.
Yeah, do you ever see ground leases in residential?
No.
No. Like if you just bought up a bunch of like plots somewhere and then you tried to sell them instead of like on the MLS for $100,000, you can just put them out on ground leases?
No. And the primary reason for that is that most people that buy a house have to get financing. And residential lending is not very sophisticated. It has to fit inside the box. When you have a ground lease and somebody wants to put financing on it, it gets complicated, because if you can imagine, let's say you are the tenant in a ground lease and you want to borrow the money to build your building. Well, the landlord doesn't want to have anything to do with that. The landlord all he wants is his check, okay? The bank looks at it and goes, well, wait a minute, if you do something wrong under the lease and the ground lessor terminates the lease or evicts you, the mortgage goes away. Because you remember I talked about life estates and what happens if you have a judgment on someone who has a life estate or a lien of any kind, and the person dies, the life estate evaporates, and so does whatever that lien is holding on to. It's the same problem with a mortgage on a leasehold. If the leasehold is extinguished, then the mortgage is not secured anymore. So what happens is you have a fairly complicated tri-party agreement between the ground lessor, the lender, and the tenant, who's the borrower, and gives the bank all kinds of rights to step in and cure the default to preserve their collateral. It also, unfortunately, I'm going to go down this path a little bit. This causes complications because, like with a mortgage foreclosure on a fee simple, the bank wants the right to sell the property after they take it back to the courthouse, so they can recover their money. That's the whole idea. They're not in the business of running properties. They want to sell the collateral. With a leasehold, now you get into another problem, because every lease, almost every lease, has a provision that restricts the right to assign it. So the landlord wants control over who the tenant is. He's made a contract with someone to be his tenant. If the bank has a free right, if they step in and take over and foreclose against the borrower and take over the lease, if they have a free right to assign the lease to recover their collateral, recover their money, now they can put someone in as the tenant that the landlord has not entered into a contract with and may or may not want. So it becomes complicated. That's why you'll never see it residential. With the slight exception of a mobile home. But that's a whole different side
Can you
thing.
explain it?
The mobile home? Well, yeah, because you rent a lot and put the tin can on it, basically. And if you don't pay your lot rent, they can evict you and require you to move the mobile home. Can't do that with a building. And by the way, that's quite a procedure. Yes, sir.
Can I just keep it though?
What?
Can I keep your mobile home if
Yeah.
similar to commercial?
No.
What about the programs where the county owns the land, they build the house, they finance, and tell you, you can live in this property forever, but they put certain
It's
stipulations.
a lease. You don't own the land, you don't own the house. It's a lease.
So they give you a mortgage and they put your name on the deed, make you pay the property tax and take care of the property.
Then you're not quite describing that they don't own the land.
It's like it's written in the deed, it's like saying that you had the land for 100 and something years, whatever, but it's still owned, like, so.
Okay, so that's a special program.
Yeah, like you can't resell it, make a profit,
Right.
you can't demolition the property. There's like a lot of stuff about it. It had to stay contained with subdivision, you had to have a certain amount of income to live in there. It was a lot of stuff, but they mortgaged you. But if you paid off the mortgage, you could live there free and clear for whenever you paid your taxes. But they had specific things that you couldn't do with the land rights.
Special program. That doesn't, that comes under specialized kinds of leases.
I feel like that was an important note to make with the ground leases because I wasn't aware of that at all.
It just doesn't. It's not that it can't happen. It just doesn't happen.
No, I was saying with the
Oh.
agreement. I didn't realize that it was so 3 people as a
Complex? Well, you see why now.
Yeah, of course.
Everybody clear on what the rights are of the 3 parties and why it's a problem? Okay.
Wait, what do you know the investment strategy behind it? Because I know there's massive skyscrapers in downtown Fort Lauderdale that have a 100-year ground lease or 50-year or whatever, 70-year, and they don't care that they're donating the building at the end of the lease.
Correct. So basically, it's a financing tool. It's like having a mortgage. So typically, your typical model would be that you buy a piece of land for cash, and you go and get a construction loan and put a building on it. All right? So let's say, for argument's sake, you're talking about a prime downtown space and it's $10 million for the land. That's a $10 million capital investment you have to make. That's your equity. Then you go borrow the construction money, but you still always have that equity to point to. If you do a ground lease, then you're making the payments, which basically means you have effectively, from an underwriting standpoint, 2 mortgages. You have a land mortgage, but it's not, even though it's a lease, and you have now a building mortgage. And now the building lender has the added risk if you don't make the ground payments. Because the ground lease comes ahead of the building mortgage with a very rare exception. And the very rare exception is when the ground lessor, the owner of the land, agrees to subordinate his interest to the construction mortgage. And that means that if the construction lender forecloses, he can take the land as well.
What? We would never agree to that.
Never is incorrect.
Who would agree to that though, and why?
It's done because it makes the deal happen. Because if everything goes the right way, then there's ground lease payments for 50 years. There's a nice building on there, so if the guy screws up, you can step in, pay off the mortgage, and take over the building. There are incentives why people do things like that.
And
No.
and you know who would do something like that and do it all the time? CRAs.
Who?
Don't they?
Okay, so That's two examples. So now I have to explain to you that when you're dealing with government programs,
What's CRA?
Community Redevelopment Agency, when you're dealing with government programs like that, it's not the normal business model. That's a whole different ballgame because it's subsidized by the government for the purpose of, you know what the R is, right? Redevelopment. So the whole purpose is you're trying to make something happen from a public policy standpoint. It's not an economic decision. So they're willing to do all of this extra stuff. The same thing with your program that you described earlier, with to help somebody have a house. The CRA wants that downtown to be rebuilt.
I understand that, but most CRAs, well, let's not get into that, but the Marlins Stadium is like that. The new Marlins Stadium, they leased it for $1 to the CRA. You know what I mean? So that wasn't for community redevelopment, that was for profit. So
Yeah, except, bring back the orange, bring back the creaking, cracking orange bowl. Wait a minute,
Thank you.
what happened?
please.
The Orange Bowl used to be there.
Yeah.
So everyone in Miami hates that the Marlins Stadium is there. They hated the previous owners of the Marlins because they lied to us and said, oh, we don't make any money on this thing, when in reality they made several millions and millions of dollars every year.
But that was a CRA that leased it out to them for $1 for
Well,
100 years.
There's also the situation where, you know, one more good play and a couple of stomping of the feet and the whole orange bowl would have gone, and everybody inside of it would have been underneath all that steel and concrete because
I don't know, I've been there for a long time and it hadn't happened yet, and there's been plenty of big games.
I know,
So,
I don't know about
I know.
that.
no, I mean, I remember, you know,
I was going
visitors coming in,
I went
we
to-
thought the whole thing was gonna
I went to the
collapse.
Orange Bowl before there were Dolphins, you don't have to tell me. So, that's true. Anyway, slightly far afield. So my point is the government programs, CRA, any of those, they have different reasons why they do it. And honestly, I know it's for profit, but you'd be surprised how much business that stadium brings into the area. You know, it's a good thing.
Well, I remember when it was the Orange Bowl before they had all the parking garages and stuff.
Yeah.
They used to pay $10 to park in someone's land, and they were making a bunch of money every weekend.
$5, no blocking.
Well,
Anyway, yes, that's what would happen. Every homeowner in the neighborhood would set up with a flag and they'd stand out front
Yep.
and they charge you $5, $10, $20 and the key is, you know, they stack them in, but the guys that were charging a little more, their theme was they wouldn't block you in, so if the game was crappy and you want to leave early, you could get your car out. Anyway, okay,
Can you buy ground leases?
yes, you buy anything.
Like, is that like a gem, or is that not like that's not like a ready available opportunity to
Yeah, sure it is.
really?
Sure it is. And what, so example, I did one to a bank in Fort Lauderdale. Bank came and built the building. My client was, I don't know who I was representing in that, because actually our firm represented both sides, which is unusual. We got a waiver, we sent one away. But he had a piece of land, leased it to the bank comes in, they build their bank, now they're paying rent. So now you have a good tenant paying rent. That's a great thing to sell.
yeah.
So it's an income stream like anything else.
But finding that piece of land that a bank wants to build on is highly desirable, you know? Like it's like one in like how many that you're gonna find a deal with.
Okay, so the simple answer is finding the piece of land is easy. The harder answer is finding a bank that now wants to continue to open up, because what's happening is, how many of you have been to the bank in the last week? Okay, 1, 2, all right? How many of you deposit checks on your phone? How many of you go to an ATM if you need cash, assuming that some of you still use cash? Okay, so, with the exception of 2 people that walked into a bank, out of a room of 15, 16 people don't go into banks anymore. You would go into a bank and a bank would be a palace. There's just an article in the paper a couple of days ago, the review. They built these beautiful buildings because, as a customer back in the day, when you saw, Wells, right?
Yeah.
When you saw this beautiful structure, these concrete poles and marble, you felt good. You knew that bank was solid as that marble. So you were okay to go in there and put your money in there. And that's how That was an image. You know, we all are used to computerized marketing and all that kind of stuff, but that's how they conveyed an image to the public that the bank was solid. You didn't hear about all the sale-leaseback deals that went on in the 70s and 80s, where the banks sold the building to Joe Investor, who leased it back to them. So all of a sudden they didn't own these palaces. Or you go into your typical palace bank today.
They would do that to get money, right?
To get money. So you go into a typical bank today, and not the newer branches, but the older branches. I mean, I went into a Bank of America up on, I think it was Cypress and Powerline. It was beautiful offices, 3-story building. I'm sure there were other offices above, and there must have been 30 teller windows. And a nice, you know how many tellers there were? 3.
I was going to say,
And 2 customers. Yeah. Okay, so what happens is they're saddled with this stuff. So now what happens, I'll give you another prime example. The intersection of commercial and federal. There was a big Bank of America there, in front of the hospital on the southwest corner. So they had a big bank building, they had their drive-through facility, and they made a deal. They tore down the building, they put a little branch, and they either sold or ground leased a big chunk of the corner to CVS to put a drugstore there. So this is what's happening. You see the branches that are going up now are little buildings. If they're still opening branches, now with the consolidation, you know, now we have BB&T and SunTrust that have just merged. So you're going to see them consolidating, and if their branches are too close, somebody's got to close a branch. So your question about ground lease opportunities, on the way over here today, I passed a property at the corner of Andrews and State Road 84. It was a rental car company, an independent rental car company, that, as of I just saw, is closed. There's a for sale sign on the fence. So that's a perfect little corner to put a ground lease, put a fast food there. It's a little too small for a drugstore probably. This drugstore's really close. But there's all kinds of opportunity. You could acquire that property. It's mostly a parking area because car rental. Tear down the little building, and you could ground lease to somebody that wanted to put a new small restaurant or something else, or possibly a bank branch.
dispensary.
Yes.
That's going up everywhere in those spots.
Well, no, because I know that, well, we're going to talk about it later, but I know that you were saying that
Sucking me in.
people don't want them in the strip, right? So they pretty
I
much
don't
have
want.
to get,
Wait.
or
They
the
can't
other
buy it.
tenants, or you can't have.
You're sucking me in, but I don't mind. I don't mind.
And after
I'm not
five-
going all the way that way, but because I want to tease with it a little bit. So listen. I told you before. I'm happy to do the side conversations because I want you guys to learn. That's what this is all about. We'd have more fun if we didn't have to do a test, but we have to have some information for testing purposes. And it's all what?
If we can get back to.
We will. Don't worry.
Yeah.
Don't worry. But wait, I want to answer
We
the
have a
question.
test next week, so.
I want to answer the question. So, the overriding issue is that cannabis is still Schedule I federally illegal substance. So, if you have a shopping center, most likely you have a mortgage on your shopping center. I had a client go to its bank to ask permission to lease to the dispensary. I won't mention any bank names, but it had to do with the stagecoaches and horses. And they said specifically that if they leased to this dispensary, they would call not only that mortgage, call it due and payable, but they would cross default every other loan this group had with the bank because it's illegal. And these banks are federally regulated. You have problems getting insurance. You can't get title insurance. There's only one underwriter, one minor underwriter that will write title insurance on a cannabis facility. So what happens is you have people that have little freestanding buildings that they buy for cash, or they get private financing through some fund that's not a bank, and that's how they can do the dispensary. Because they're making so much money from it that they can afford to pay the extra costs to jump the hoops.
Yeah, it was, when you said that the other day, and I was driving, because there's a lot of dispensaries going up, and most of them are standing single buildings.
Yeah.
They
Right.
on my street where my office is at, there's a major highway, and I go up and down it, and I just realized, because you said that, and they make funny names, like this one's one plant, whatever, and I was just driving, I looked at the light, and I was like, oh my God. And I realized up and down, I started checking, there's like 5 of them popped up in the last 6 months on my.
Where? What part of town?
Boynton Beach.
Where?
Boynton Beach.
Okay. Boynton Beach is one of the friendly communities. When the
And
state.
I mean, I'm by the city. There's one right next to
No,
the
I
city
know.
hall.
I was working on on a deal up there. See, what happened was when they changed the law, many of the communities passed bans, and they said no, you can't. So the state law basically says you can either ban it completely, or you can regulate it as you would a pharmacy. But those are your only 2 choices. And so most of the communities, the nicer communities, if you will, said no, not here. It softened a lot. There were a couple of places. Boynton was one. I think Lauderhill was another. There were a few places, probably Miramar, a few places where they wanted the business. So they said, okay, and that's where the dispensaries. Now they're in Fort Lauderdale.
Yeah.
Dania's got them. I've seen them along Federal Highway there. So
Yeah, they're coming out.
they're coming out, and it's going to get better. It's just
Well,
it'll
there's
get better.
too much money to be made in that.
It's
from what I hear.
been that way forever. It's just been, honestly, in personal opinion, it's stupid. This should have happened 40 years ago, at least. But the liquor lobby was too strong. And in fact, it wasn't illegal until around the 1930s. And I do believe it was the alcohol lobby. The reason, by the way, that it was known for so many years as marijuana is because that is a Spanish word for it. It sounds foreign to the people in Iowa, and therefore it's bad. Cannabis is a correct name, which is, most of the things you see, you're going to see cannabis. But it was dubbed, there's so many different nicknames. But and unfortunately, the practice just lends itself to jokes. It's a budding practice. I'm sorry. I will try and control myself. Oh, our firm is growing. We're growing like a weed. May I move on, please?
Lease provisions.
Okay. Rent. Doesn't rent sound like a pretty bland, normal thing, right? Rent? It's easy. It's actually, I actually got a definition into the statute. I was trying to accomplish something a little bit sneaky in committee. There is a definition in the statute that rent is the periodic payment for the use of the property. The reason I wrote that and got that into the statute, when they added a phrase after that, they added for purposes of this chapter, meaning chapter 83, the landlord-tenant statute. I was trying to sideways get around the imposition of sales tax on other payments of rent. And we'll get to that, some of the expenses, trying to define the rent specifically because the sales tax statute says rent. If I had gotten the definition in blanketly, then we wouldn't be paying tax on some of the other things. So there's different ways. What you all think of as rent, pardon me, but allow me to change forms for a minute. For some reason, they're making the maneuvering difficult, but I'll get you there. I want to show you the lease. Nope. Bear with me a second. Because there's different kinds of rent and different ways to compute it.
That's the same document. That's not it. It's gonna be it's gonna be D1 or D. You're looking for your lease.
Yeah.
Commercial lease. It's D1 or D. LD1.
No, that's the wrong module. How did that happen? Okay. Did you see it in what I sent out? Did you see the commercial lease come up? Or did I screw that up completely?
I remember you had a commercial lease on the in one of the earlier downloads. No, that's the ones that you blacked out. You had a commercial lease in here.
I thought that I did. All right, I'll work around it for the moment. Let's see what I can do to fix it. Don't worry about it. We'll get there. Of course. Bear with me a second, I'm sorry. Really?
I think you refresh it, we are.
I'm being tortured.
Try refresh.
Now they tell you have different passwords for everything. And then you do that. You can't remember which one goes with what. Let me see if I had it from last year. Doubt it. Maybe. Say. Wines. What number is it? Oh, there we go. Okay. Okay, sorry. So there's your basic red your base red paragraph. Base rent's real easy. We typically, there's different ways to state base rent. In this particular form that you see, it says initial annual rent, and that would imply that there's going to be a change. Usually, if I know what the percentage changes are going to be from year to year, like we agree that's going to be 3% a year for every year, I'll do a matrix. I'll do an actual spreadsheet table in there, and I'll have it laid out by year, by month, with tax. But you see, that's only the first sentence. The second sentence talks about common expenses and other sums required to be paid shall be deemed additional rent. The reason they are deemed additional rent is for collection purposes, because you have certain rights under the lease and under Florida law in collecting rent, which is different than other remedies that you have for being in default. So for example, if the tenant, and if you look at, say, a typical office or retail lease that has a large expense component, you could have a base rent of $25 and common expenses of another $20. So you see that it's a huge amount. So when if the tenant stops paying and you go to evict, and the tenant wants to throw up a defense in court, the statutes provide that the tenant has to pay the rent into the court registry in order to maintain any defense other than payment. So if it was only the base rent, it would be a lot less than the whole thing. So that's why it's defined as rent. Unfortunately, the sales tax statute imposes sales tax on the additional rent as well as the base rent. And you'll see in this paragraph that it says just that. So base rent can be computed in a whole bunch of different ways. It can be computed, let's say you have a 3-year lease. You might know what the rent is going to be for the 3 years. It's just an agreement between the parties, in which case I would state the rent for the whole 3 years, because if there were a default, and we'll get to defaults and remedies later, you'd be entitled to recover all of that number. So you'd want to make sure to state that the contract was not just to pay so much a month, but to pay total of this payable in monthly installments. That's why the annual rent is there, broken down into installments. It's for collection purposes. You
They
also,
had a similar thing in the residential, didn't they?
yes, yes, that doesn't change.
Okay.
When it's doing payable, sales tax, late charges, simple things like that. I'm just going to run through so you can get an idea. You should, if you don't have this, I'll make sure that you do, just so you have it. But you'll see other things the tenant's got to comply with the law. Come on. And of course, these things change depending upon whether I'm representing a landlord or a tenant, but it talks about compliance with typically governmental things, including the Americans with Disabilities Act, non-structural, the structural should be the landlord's issue. Landlord doesn't want to be responsible for the things that the tenant brings into the building if there's a problem. Security deposit, unlike a residential security deposit in a commercial lease, the landlord can put it into their regular account. They don't have to account for it until the end of the lease. They don't have to pay interest on it. In a residential lease, it's carefully restricted by statute. It has to be segregated. They have to pay interest. So that's a huge difference between residential and commercial. Also,
Can you say that again?
sure. In a residential lease, the statute requires the landlord to segregate the security deposit in a separate account and to pay interest on it, either the interest he earns or a certain minimum amount of interest that the statute provides.
Even if they don't keep it in an interest-bearing account?
Yes. If you, in a commercial lease, and it says so right in the paragraph, the landlord has the right to commingle it with their other funds and not to pay interest, and all they have to do is at the end of the lease, account for it. It also provides that if the tenant does something wrong, either fails to pay rent or doesn't maintain, the landlord has the right, but not the obligation, to use the security deposit to cure the default. Then you can come back to the tenant and say, restore it. All contract provisions. There's an additional paragraph which is really a recitation of one of the Florida statutes, unless you have something to the contrary, that says that as additional security for the lease, the landlord has a lien on all the personal property. So again, we'll get back to our office, and this office is now stocked with desks and chairs. The landlord has a lien for rent on the desks and chairs. And theoretically, although it's not done frequently in something like this, the landlord could seize them to help pay for the rent. More likely situation would be a restaurant, although then you get into landlord's lien versus a vendor's lien. Because if you're operating a restaurant and you're going to have to buy refrigerators and stoves and coolers and do a lot of build out, you're going to get a loan from the bank. The bank's going to want to come ahead of the landlord. And that's a whole back and forth and a fight amongst the secured parties in that situation. It's beyond the scope of what we're talking about. It's also, restaurant leases are also typically, if there's a failure, the landlord will work something out with the restaurant tenant, because used restaurant equipment is worth a fraction of what it is new. And so you'll make a deal where the tenant will leave the equipment in exchange for being released from the lease, and the landlord can then rent an operating restaurant property to the next tenant that comes in, without the next tenant having to make a huge investment. The landlord in that case is leasing the premises with the equipment, and of course the rent's a little higher because it's like renting a furnished apartment. Okay, things the tenant has to pay. What you see as taxes and utility expenses, that's real easy. The first paragraph deals with taxes that are just imposed on the tenant for operating their business. The landlord wants the covenant in there because if you don't pay your taxes, there can be a lien against the tenant and against the tenant's property. That lien can cause a problem because it just can cause a problem for the tenant, which means the tenant can't perform its lease, so there's a covenant to pay. The second paragraph, that 8B, are other charges that the tenant pays for to third parties. Utilities, could be electric, could be water, sewer, cable, I think I have that in there. Yeah. Trash removal, things like that. All things that they want the tenant to pay before it becomes delinquent. Water particularly is always a problem because that's one of the few things that can be a lien on the landlord's property, so you want to make sure that's paid. Then comes the more complicated stuff. That's common expenses. Common expenses, you've probably heard the word CAM. CAM really refers to the third one, the common area maintenance. The other two are real estate taxes and insurance. So, backing away from the words, these are all expenses that a person pays when they own property. They have to pay real estate taxes on their property. They have to keep their property insured, and they have to maintain their property. Easy enough. When you enter into a contract for someone else to occupy and use your property, by this contract, we are shifting the burden to the tenant to reimburse the landlord effectively for these various expenses, so that the base rent, that first number we talked about, is net to the landlord. And that's how that's a net lease. In a net lease, all the expenses are passed through to the tenant, and the rent goes into the landlord's pocket, and that's his return on his investment, not taking debt service into account. Because these are the landlord's expenses that the tenant is paying for, they are deemed to be, anybody? Additional rent. They are additional compensation that's being paid by the tenant to the landlord for the use of the property that would not otherwise be the tenant's expense. It's rent. We define it as rent, I think, as additional rent. We define it that way because of the collection purposes. And they're all subject to sales tax, because that's just how the state makes money in the state of Florida, because we don't have income tax, we don't have a state tax. So we have to get taxes like this, and documentary stamp transfer tax, and all kinds of things like that, because otherwise that's how you run the state. Sales tax, property taxes, and things like that. Also, you see up there it talks about the pro rata share. So, back to my example of this office, this room. So this room, let's say this room is 2% of this building. And how would you determine that? What's that?
So the square footage of this.
Square footage. Exactly what it says. So you see the rentable, see the word rentable is in there, that takes back that load factor gets in there. So you have the rentable square footage as the numerator, and the rentable square footage of the entire building or property, depending upon how it's defined, as the denominator, and that becomes the tenant's pro rata share. That's their share of the costs. So that pro rata share is going to get applied to all these expenses. More complicated leases, shopping center leases and such, and different ways to do it, they have long, long lists defining what these expenses are. There are other, various ways to do this. Now, in a triple net lease, it all gets passed through. By the way, so defining the common areas, we've been through that. It's really not too difficult. And if you don't, I promise you will have this document. I don't know how it didn't get into our module, but you'll get it. And then it talks about in E, at the end of the year, landlord does a reconciliation. The tenant is paying 1/12 each month of these expenses. Landlord gets the actual expenses for the year, do a reconciliation, and there's a catch-up payment, one backwards or forwards. Use provision is important because if you have a multi-tenant property, especially a shopping center, you want to watch your tenant mix. Worst, you want to watch your tenant mix, and although we don't have one here, well, I'll show you, I have another one that I uploaded, maybe I'll find it and put it on the screen later. Exclusives, where you're granting one tenant the right to be the only tenant in that property that can sell widgets. And that's a business arrangement that's done because you don't want two widget sellers in the same shopping center, bad for business, and you want the national widget company to come into your shopping center because they're good because they bring people to go into the other stores. Of course, you talk about bringing the dispensary in, they're good because Dunkin' Donuts likes it, the Pizza Hut likes it, it's all, okay? So that is a good tenant mix. So the importance of the use is when you get to the assignment provisions, the tenant can assign the lease with certain permissions, but the right to assign the lease does not change this provision. So if you have a store that has the right to sell widgets, not just the exclusive, but the right to sell widgets, and you assign it to another company, that other company is still bound by this use provision and can only sell widgets, or whatever it is you define that they're allowed to do in there. Obviously, the more strength the tenant has, big national tenants are going to come and they're going to want as much flexibility in that use clause as possible, because you might have all of a sudden, everybody's buying their widgets online. And so nobody's coming into the National Widget Company's store. And it's dead. But they're stuck with this 10-year lease and they made a great deal, and they can't get out of it because we're a big company. Now they want to do something else in there. They want to open up a widget service company because the widgets need to be serviced periodically. But you can't because the use is only for the sale of widgets, not sales and service. But service you can't get on the internet, except unless you want to mail it away, and it depends on how big your widget is. So now they want to change it. I may have mentioned in talking earlier on, I had a client that bought a retail center at the depths of the recession in 2008. It was 30% occupied. There in the middle had been, I believe it was a Winn-Dixie, of 50,000 square feet. He took that and he divided at least 30,000 to a Crunch gym, and then the other 20,000 he built an indoor soccer facility. Things you can't get on the internet. He's got an indoor batting cage, one, and at one end of he ground leased a piece of the shopping center to someone who built an indoor rock climbing facility. All things you can't, so the shopping center is booming. And he just totally turned it around. So the use clause is important. Access, in most normal leases, the landlord's going to want to have access to the premises. Cannabis leases are very different that way. We will get to that, I promise. Repairs. This is usually negotiable, but in your typical, even in all but the absolute pure single-user net lease, in almost every case, the landlord at a minimum is obligated for roof and structure. Everything else can be shifted across to the tenant, but those are usually accepted a ground lease or a long-term single-building, single-user property. The landlord maintains roof and structure. The arguments on middle-term leases come in over the equipment like the air conditioning, which is expensive. Then you get into the dichotomy between repairs and replacement. Yes, the tenant's going to make repairs up to, depending on the sizes, it could be $1,000 a year, it could be $5,000 a year, it could be $10,000 a year, but if it needs to be replaced, it's the landlord's problem. And that's all based upon the size of the space, the amount of the rent, the length of the lease. It's all economics. Alterations deals with changes that the tenant is allowed to make in the space during the term of the lease. It's construction. When you have construction, you have risks to the landlord. The risks, very simply, are they don't pay for it. They they start tearing things up, they start making improvements, they don't pay, and then it becomes liens, and the tenant goes away, and the landlord's stuck fighting with contractors. It could be bad work. It could be unpermitted work. It could be turning the place into really crappy looking, putting weird things in there that are expensive to take out. So this whole litany, and I'm not going to go through the whole thing, but this whole paragraph deals with the tenant going to the landlord to get permission, to get the plans and specs approved, to make sure they get permits, to make sure they get the proper inspections, they close the permits out, that they do everything the way they're supposed to do it. So the biggest issue with alterations of this kind, and I don't deal with it here, but I see it in a lot of leases, is what happens at the end of the lease. What happens when the landlord has permitted the tenant to come and do all these changes inside, to put extra walls in, to do things like that? Is the tenant obligated after 5 years to come back in and do construction to clear all this out? Or does it become the property of the landlord and the landlord can keep it the way it is or prepare it differently for the next tenant? That's always a back and forth. And my usual solution representing the tenant is if the landlord tries to say, tenant, you're going to have to take it all out at the end, my position for the tenant is to say, landlord, as long as you tell us that when you approve the alterations up front, we don't want to make the alterations and then find out at the end of the day you want us to do the construction twice, basically. So we try and negotiate that at the beginning.
So that's separate from tenant improvements, or that's
It's part of the tenant. It's the removal of the tenant improvements.
But
So
like
tenant improvements usually, when you talk about tenant improvements, that's at the beginning of the lease. That's a separate negotiation. This is during the term of the lease.
Okay.
Same principles all apply, exactly the same principles. But usually the tenant improvements are an upfront negotiation. It's part of the deal to get the tenant in there. The landlord may pay for it and do the work, or the landlord may pay for it, the tenant does the work. There's a whole litany of how to do that, and I probably have some materials that I could share with you on that as well. Just to give you an example of a situation where this is a problem, even with the tenant improvements, go back to your bank branch. You have a bank branch, because some of them are in buildings, they're not freestanding. And you know what you find in a bank branch? Banker, what do you find in a bank branch?
Oh, you want me to list everything that's?
No, I want something that's a problem for the landlord at the end of the day, at the end of the lease. Big problem. Who said that?
The safe, all vaults.
Vault.
Yeah. Well, that's why in a lot of the new banks, they will not put a safety deposit box vault in there.
But there's
They don't
still,
want it.
there's still a big box to keep the money in.
Well, that one, but yeah, all the
Right,
new
so
ones,
two different things.
Yeah, they don't want to deal with that.
So, absent a provision in the lease, which would be an unusual provision actually unless you're thinking about it up front, is because you don't think the banks are going to go away. But when the bank does go away at the end of the day because they don't own the building, which is a little unusual, they could leave this gargantuan steel thing built into the walls, which, yeah, make a great safe room if that's what you're looking for, but it's also a real problem.
They're actually in the ground, not on the wall.
What?
They're both
The new
bolted
ones.
to the ground. Yeah.
Well, sometimes yes, and sometimes it's an entire room. So,
Well, I was just talking about like the cash vault, because I've worked in 5 different locations. They've all been boom, nailed, not nailed, but like bolted to the floor.
okay, so it's a little box.
I wouldn't call it little.
Okay. There was a bank when I was practicing in Hollywood years ago. There was a SunTrust on Hollywood Boulevard that had actually been named of different things and went back to the 1920s. This bank had a vault door. Now the vault, the door was probably the size of this screen, but all the way to the floor.
So that was more like a safety deposit box.
No, this was the bank vault. There may have been boxes in there too, but this was a walk-in gargantuan with probably when you closed the door, because it was all glass or plexi or something, so you could see it, because it was very cool, very historical, but it really worked. This mammoth thing closed, and they would, just like you see it in the movies, you twist this large wheel and the bolts, and there must have been 50 of them at least, all around the door. And they would extend into the wall, and that's how the vault closed. And it was such a classic looking thing and so well made and all that it was historic. Unfortunately, they sold the building. I do not know what happened to the vault. And they went to a little branch around the corner because they don't need the big 3-story building. The other interesting thing about that, and another lease problem that you could come into with banks, in particular while we're talking about banks, is that before Florida allowed branch banking, I don't mean BB&T either, the law was that each bank had to have a separate charter. Each office of the bank had to have a separate charter. So if you had Barnett on Hallandale Beach Boulevard and you had Barnett in downtown Fort Lauderdale, those were 2 separate bank charters. As an extension of that rule, the drive-through teller had to be physically connected to the bank, or it was deemed to be a different office. So they had, at the same bank in Hollywood, they had an underground tunnel that connected the bank to the drive-throughs that were in the parking lot. When they decided to do away with it when all the laws changed, they had to dig this out, and the whole street shook. My office at the time was like across the street. And you just, all day for weeks, the whole ground shook. Kind of like what happened in Miami last week.
And this quick little trivia, Wells Fargo has the first ever charter issued by the U.S. government.
That doesn't surprise me.
Yeah.
The first 2 savings and loan charters, which were issued in the 30s as part of one of the acts during the recession, were out of Miami. There was First Federal, which became, you may not remember the name, AmeriFirst, because it really had a United States Savings Loan Charter #1. And there was Miami Beach Federal, which became Financial Federal. They were based on Lincoln Road. They had #2.
Wow.
because the two guys from the two different places, they were the first two guys in line when they were making the applications.
What's the savings and loans? Is that a bank or like what is that?
It used to be, okay, so it used to be a type of bank that did no commercial business. Their business, I think I was talking about this early on.
Yeah.
Their business model was you would go in there with your cash and you put it into a savings account. You'd actually get a little passbook, which they would stamp with a machine. Or maybe they wrote on it at one point.
And then they loan it back out.
Right, and so they would pay you 3% for your money, and they'd make mortgages at 5%. They'd make 2 points, and they made money all day long. That's the days. I mean, again, please forgive this, but you're all a little too young to know of these, where they would have promotions when they needed money, and if you made a deposit of $5,000, you'd get a toaster or some similar type of thing like that. And that's how they brought people into the bank. Unfortunately, as the interest rates became volatile in the 70s and 80s, these banks that had the long-term, low-rate mortgages couldn't survive because they didn't. It was against their business model to do adjustable rate financing, which you think is crazy today.
So what happens? They get bought out by
They
someone?
went broke.
No, they all went broke.
That was one of the
Go
first.
online and look at savings and loan scandals. And
Yeah, I
they
know.
all-
Big savings
That was
and loan
like
crisis,
that
but-
was like the foreclosure recession we had in that time. That was like
It's a little bit smaller, but what was the solution to it? They didn't just like let it.
Well, some of them were able to convert to commercial banking. Some of them they expanded some of their powers so that they could like issue credit cards and do other kinds of businesses.
But didn't they become the credit unions? Did they?
No.
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 The credit unions came
Different.
after.
Credit unions were different. Credit unions were typically associated with big businesses, like airlines or big corporations.
But I mean, the credit
Initially.
unions took their place because before people used to go to savings and loans. Now that people started going to credit unions,
Right.
which servers on
Right. Similar purpose.
Yeah.
Yes. I mean, savings and loan, you couldn't even have a checking account. You couldn't even write a check on it. You just have to go to the bank and present your passbook and take your money out. They might issue a bank check, but other than that, no, it wasn't. They didn't do commercial banking business.
Okay, so but there was no like quantitative easing or anything to like, how big was the impact on the economy? Like, was there anything that the government did to help rebuild what went on, or did they just kind of and then like restart?
No, I really don't think there was. Certainly not like what you've seen, you know, Too Big to Fail, all that kind of stuff.
Yeah, exactly.
No.
So it really exploded then.
Yeah, imploded.
Exploded
Yes.
without any assistance back then.
Yes. I mean, there was government insurance on accounts.
Up to a certain amount.
Right.
But the
You know.
savings and loans was the first catalyst that started all these laws in the banking industry, and these are all the laws that the savings loan. That's what I'm trying to tell you. That was like the big first recession that we had from banking was the savings and loans, and then they started all these laws and started all these regulations for creating the charters and all that. If you look into like the mortgage industry, any history, it brings it up to why we're here today.
So
It's like always residential. It's all like the
that was all residential.
average people like, they're not as logical. Like econ.
That's nice.
No, but like-
That's nicely said. So I'll give you an
No,
example. I'll give you an example. I was representing a savings and loan. Okay, my first job, the bank was working for a law firm that represented a savings and loan, was probably 2/3 of our business, and I was reviewing loan packages and closing loans, and people were coming from, I'm going to say South America, just at the time. This is in the late 70s, early 80s, and they were buying condominiums, and they were signing 14% mortgages. That was the market. So you can just imagine when things went south a little bit in the middle of the 80s, what happened to all these 14% loans? They all got foreclosed. So the rates were nuts. And if you have, you know, it just doesn't work.
the ability for savings and loans for someone to like, you know, offer 3% and then the rates go up, that also.
Well, that was just a death knell because how are you you can't pay out 3%. Well, no one's gonna take a 3% rate on their savings when mortgage rates are at 14. The savings rate went way up as well. It's just the opposite of what you see today.
That doesn't really have to do with the residential marketplace, it's more the savings and loans strategy.
It was the interest rates. More than, you know, it wasn't even a strategy. It was a way to make home loans affordable. Okay? A few more things, and then we'll take a break. Insurance. Again, you have somebody occupying your space. So you want to make sure, you as a landlord want to make sure that if somebody trips and falls, as a simple example, and there's a lawsuit, the tenant's got to carry liability insurance. The bigger the space, the more dangerous the use, the higher the number. I think I have $1 million in this one. But it's, you know, it goes as high as $5 million if it's a big single-purpose freestanding building. Then we have the tenant insuring their own stuff, and the insurance, it can go in many different directions, depending upon the nature of the building. Again, I keep referring to a single-tenant freestanding building, and that's not quite a ground lease, but it's closer to a ground lease where you have a freestanding dispensary, for argument's sake, or whatever it is, and you're leasing that whole building to one tenant. Now you're going to say, tenant, you go buy all the insurance. Liability insurance, you insure the structure, you insure what's inside, and it's all your expense. Don't even bother me, but make sure that the landlord is named on your liability and your property insurance as an additional insured on liability and as a loss payee on property insurance, and that's fine. In a situation where we have our office building or a retail building, the landlord's going to carry their coverage on the structure, and they're going to charge the tenant their pro rata share of the expense. But these are just the obligations of who has to carry
It's
it.
the same thing on your, like an auto loan too, no?
Yes, yes. Because if the car gets destroyed, the bank wants to get paid. Subordination is fairly simple. It's just a statement that the mortgage comes ahead of the lease, because that's how it has to be. Not too much detail necessary. Assignment and subleasing, this is always an issue, because the landlord wants to control who's occupying, the tenant wants some flexibility. There's different ways to do it. This one is the vanilla way to do it, which says that the tenant may not assign or sublease without the landlord's consent, which consent will not be unreasonably withheld. You can then go on and describe this many reasons why you can withhold consent. Financial reasons, business experience, type of business, other tenants in the building. I've seen in offices they don't want governmental tenants, they don't want any tenant the landlord's been negotiating with in the last 6 months for other space, other tenants in the building with a right to expand, blah, 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 blah. There's all kinds of things you can do. However, if you said nothing but without the landlord's consent, period, under Florida law, the landlord is required to be commercially reasonable. That is not the same in every state. But in Florida, there was a requirement to be commercially reasonable. There's actually a case back in the 70s or whatever that defined what the standards of commercial reasonableness were in the assignment of a lease. But you do have the right, as a landlord, if the tenant agrees to it, to be arbitrary or sole discretion. If you look at the next paragraph, we talk about subleasing. And the subleasing standard talks about sole and absolute discretion. And it even says why. So when the tenant goes to court and says, Judge, it's not fair that it's in their sole and absolute discretion. Why would they do such a horrible thing to me? Well, here, we give an explanation. Because if the tenant is leasing 10,000 square feet, and the tenant's only using 5,000 square feet, and now wants to sublease the other 5,000 square feet to somebody else, and the rents in the area have gone up, theoretically, the tenant could be making a profit. Okay, he could be renting it for $25 a foot from the landlord and get $30 a square foot from a subtenant. So we have two things that we say right in here. Number one, the reason we're going to have it in our sole discretion is because we don't want this tenant competing with us as a landlord. We own the property, you don't. You leased it to operate your business, you didn't lease it to go into competition with the landlord. So, that's the reason it says so there, and then it says, if there's that profit to be made, that's fine, because you can cover your expenses, but anything over the 25 comes to the landlord, it's our building. Now that gets negotiated down to 50-50 sometimes. It depends on the market and the strength of it. 50-50 is not unreasonable because everybody's doing okay from it. Now, I actually don't want to go into excruciating detail on this, but I think it was a book chapter I wrote on using that as a way to save tenants during a downturn. You know, landlords have the ability to work with their tenants, and in a downturn market, if the tenant has the 10,000 square feet and their business is not doing well, it's to everybody's best interest for the landlord to say, okay, you can sublease half of it, or if depending upon the market, the landlord might say, I'll let you out, I'll take back half. That's called recapture, where instead of allowing the tenant to transfer it either by an assignment or a subleasing, the landlord takes it back. Recapture is the word. So by doing that, by working with the tenant, the landlord is helping the tenant save his business. Everybody benefits. The tenant stays in business. The landlord has at least half of the space rented instead of all of it empty, and it's good for everybody. I'm not going to go through the details of condemnation and indemnification and the heavier legal topics in the lease that you really don't need. Destruction of the premises is always a problem because we have things like hurricanes. I argue with lawyers from other parts of the country because in the most situations this doesn't come up as an issue. There might be a fire, yes, but that's kind of rare. Having a hurricane is not so rare. The other issue is that and this is I always find this to be an argument, most office buildings, for example, are sealed. You can't open your windows. If you're renting a business office, hold on one second. If you're renting a business office and you go to work, and what's the first thing you do when you sit down at your desk? What's the first thing you touch?
Your computer.
Thank you. Perfect answer. Can you work if you don't have electricity?
Depends
No.
on the job.
You can. Typically,
No.
Using the computer.
based upon that answer, the answer is no. And if the windows are sealed, you can't breathe. I mean, especially if it's in the summertime. So, what I have tried from a tenant standpoint to work into the lease is that if there is a hurricane or some other disaster or some other casualty, and it knocks out utilities to the building, even if the physical structure hasn't been damaged, that's deemed to be untenantable, and there should be a rent abatement. And that's a great argument back and forth, because the landlord said, hey, it's not my fault. I didn't turn the electricity off. Well, it's a question of who bears the risk. Because honestly, the original concept of being untenantable would be if the ceiling was hanging down and dripping water, you can't work in the space. We used to have a pipe break in our office. Luckily, it was contained quickly. But there's like a couple of workstations with big blowers and all. But your typical situation is you have no utilities. You have no utilities, you can't work. So then it becomes
landlords add generators or anything like that? Because I know.
sometimes.
Okay, I know by law in Florida that they made like all the gas stations.
Gas stations, yes.
install the
And the reason is
generators.
because if you need to evacuate, you need to put gas in your car.
Yeah.
That's the reason for that. When Hurricane Wilma came through, my office was up in Cypress Creek, there was a generator in the building. It didn't work. And at the time, the firm had two offices, one in Fort Lauderdale and one in Orlando. Maybe a third one in Boca, small one. The servers were in the Fort Lauderdale office.
Some people in Orlando couldn't work.
Correct, and they were furious because nothing had happened to them. Obviously, a change was made. Now we're in a bunker in Miami. We're national, so we have a redundancy bunker somewhere out in the west, and everybody works out. Everything ties in there. But back then, nobody thought about that. So the one facility went down, the whole firm went down. Ooh, the managing partner in Orlando was very unhappy, and he gets grumpy. Everybody's afraid of him. All right, 2:15. I'm gonna call a break. There's a few more things I want to talk about in this document, and then we'll get into some other types of things. Anybody falling asleep? Am I doing okay here with this? This happens to be this. If you haven't guessed this by the way I'm going through this stuff, this happens to be something I really enjoy and do a lot of.
Answer that.
Kill the camera, please.